and your affiliation, your position on House Bill 1491.
My name is Jay Harvey. Here on behalf of Texas Trial Lawyers and myself, opposed to HB 1491. I want to make 5 basic points. First off, there has not been a showing of need while this cap is in place, just as the prior witness told us. Notwithstanding, there have been no lawsuits. His insurance rates have gone up. So, or he's talked about the cost of his insurance. So the fact that there is a cap or not a cap, that is not the factor. You measure that against the losses that the families have that don't have access to the courts. We heard Chairman Muir talk about in his bill how important access to the courts is. With a $100,000 non-economic damage cap, these families are not going to have access to the courts because lawyers aren't going to take the case because in good faith we can't. Because the costs of developing these cases, fees, reimbursements that we have to do to health insurance, the clients aren't going to get any money left, and we're not going to take those cases, and we don't take those cases. We don't take the $100,000 Texas Tort Claims Act cost.
Wait. You said they don't have access to the courts or access to lawyers?
Well, I think in a malpractice case, they can, in good faith, have access to the court without a lawyer. And so if they don't have a lawyer that is willing to accept the case, with all reason, they're not going to have access to it.
And tell me again what your analysis on why an attorney wouldn't accept this case, one of the cases?
Because the limitation of the non-economic damage cap is so profound that it just makes the cases not economically feasible to handle these cases.
Are your attorney's fees included in the non-economic damages?
Our attorney's fees are included in all the damages.
So you would get, a patient would get compensatory damages, actual damages?
Correct.
No, economic, and then non-economic damages, your attorney's fees would come out of the entire judgment?
Sure. If there are economic damages. Remember, there are many of these cases that do not include economic damages of any great significance. Economic damages, such as medical costs, have to be reimbursed back to the provider. To the health insurer, or to Medicare, or to Medicaid. So that money doesn't go to the clients. Lost earnings, well, that's a factor. But the limitation of recovery is so significant that there's not going to be reasonably an opportunity for these people to have access to courts. And even in that circumstance that you bring up, Mr. Chairman,
go ahead.
Even in that circumstance, that means there's no way the client is going to get reimbursed back to full, because he's not. When the lawyers are taking fees on everything, the non-economic damages would oftentimes be able to pay those fees so that they're made whole on their economics. This is going to prevent that. The third aspect I want to point out is we already have the smallest cap anywhere in the country. And we have seen this cap, and it hasn't changed in 20 years. Final thing, and this is a technical thing on the bill. Section 4 of the bill puts a $100,000 cap on wrongful death claims. A hard cap, not non-economic, on all damages. In 2003, there was an amendment that passed that said the legislature can put a cap on any type of damages except economic. Section 4 of this bill caps economic damages in a wrongful death case, period. That part of this bill cannot be constitutional based upon the amendment passed in 2003. We recognize the problems that these rural hospitals are having. The problems are reimbursements, not liability claims.
Okay, Representative Johnson.
Thank you, Mr. Harvey. Can you address one of my questions that I was asking of the other gentleman about what the impact of having this bill in Section 2 about capping $100,000 to all parties, regardless, it says regardless of the number of defendants, and what that would do to a claimant, and how does that affect parties who would otherwise have the $250,000 cap would be bootstrapped into this?
Absolutely. If you have a physician defendant and a hospital defendant, you would have 2 caps. This bill is trying to loop the second classification of physician defendant in by saying regardless of the number of defendants. It's inconsistent with the existing law, and if it was to bring in those people, these physicians, which is beyond the issue that we're talking about.
Right. And then can you also, I want to just provide some clarity for you, Mr. Chairman, on an issue you brought up about just how the monies are allocated. Can you also just provide some commentary to the committee about how the case expenses are and what those typically, how that plays into a medical malpractice case in just terms of the sheer volume of the case expenses and how that affects the plaintiff's recovery?
Well, of course, the legislature put a burden on us to require that we have an expert report before we initiate litigation, which is fine. We comply with that. That means each case we file, we have had to retain an expert, get a report. These reports, preliminary reports, are $3,000, $4,000, $5,000 oftentimes. Litigation costs in the case, because of experts, is tremendous. Even in I'm going to call it a relatively simple medical negligence case, a relatively simple one expert medical negligence case, to get that case to trial, that's going to be expenses. I'm talking about out-of-pocket expenses, $30,000, $40,000, maybe even $50,000 in a single expert case. So when we take a limit on non-economics, we have to reimburse health expenses. There's generally a relatively small amount of earnings loss that is always based on net income. There's no way that these plaintiffs are getting fully compensated. And when we take all of that money out of the settlement and you look at your client and say, well, the lawyers got theirs, the health insurer got theirs, I'm sorry, you're getting left out. I don't take those cases because I'm not going to have that conversation with the client and say, everybody got paid but you. And so they're not getting access to the courts because, is there a path? Yes. But is there a realistic path? No. Thank you.
Members, other questions? Okay.
Thank you.
Thanks, Mr. Harvey. The chair calls Brian Jackson.